Welcome, everybody, to our class on bail reform. Our speaker today is Adam Shepard. Prior to joining the Shepard Law Firm, Adam gained extensive experience at the Cook County Public Defender's Office, where he was honored to be the recipient of the Jack Carey Merit Award Scholarship. He's been repeatedly recognized as a super lawyer in the area of criminal defense in Super Lawyers Magazine and Chicago Magazine. He's also been honored by Leading Lawyer Magazine to be named as an emerging lawyer in the area of criminal defense, and has been selected as a panel attorney in federal court, U.S. District Court, Northern District of Illinois. Adam served multiple terms as co-editor-in-chief of the Young Lawyers Journal CBA Record Magazine, and continues to serve on the editorial board of the Chicago Bar Association. He's taught continuing legal education seminars for the CBA and for Decalogue. We've had him here before, on state and federal criminal law issues, and he's been a guest lecturer at John Marshall Law School on search and seizure issues in the school setting. Adam is a board member of Decalogue and a frequent contributor to the Tablets, our semi-annual publication. And with that, I will turn it over to Adam.
Thank you all for being here. Hot topic of law these days, the new bail law. Unofficial names are the Safety Act and the Pretrial Fairness Act. And as you know, the thrust of it is that it eliminated cash bail. And the new system is kind of a hold or release system, which for defendants facing less serious charges can be good. They don't have to face a bond that they couldn't make and be in jail for that purpose. But for a lot of serious cases, like my firm handles, it leads to a battle on whether the person could be released. So just a quick editorial at the beginning, a bit of a wolf in sheep's clothing, in my personal opinion, because on serious cases where defendants otherwise had an ability, a chance to post bond, even if it was a high bond, their family might be able to raise it. Instead, now they're facing the prospect of detention. And with that, I'm going to begin the PowerPoint. If you have any questions in the interim, please put them in the chat, and Aviva and I will get to them either in the middle of the lecture or at the end. A little humor to start us off. The officers are saying they don't want to release him, but he has this card you might remember from Monopoly, the get out of jail free card. Given that there's no cash bond anymore, I thought it apropos. So the statute where you could find the law is 725. It's Chapter 5, Article 110. As I say, the common names are the Pretrial Fairness Act and the Safety Act, but that's the statute, 5/110. So what happens now when somebody gets arrested? Let's say it's an arrest for a felony, because many low-level misdemeanors that aren't Class A misdemeanors, and even some Class A misdemeanors, people are being released right from the police station, and I'll get to that. But I want to just generally address what happens when somebody's arrested on a felony offense or domestic-related misdemeanor offenses. So they go before a judge on an initial appearance. The judge first determines whether there's probable cause to hold them. I should note that if the person is arrested off a warrant, the judge does not have to find that make that probable cause determination. It's already satisfied by the warrant. So the next step is the judge looks whether it's a detainable offense or a non-detainable offense. And in a moment, we'll get to the list of detainable offenses. So assuming it is a detainable offense, then it goes to the prosecution to whether they're going to file a petition to detain someone or just a request for conditions such as electronic monitoring. And we're going to talk about practice pointers in a moment. The real move is to call the state's attorney's office ahead of time, assuming you were engaged ahead of time, knowing that the client's going to have a bond hearing, and find out whether they're seeking to detain the person or not, so you could prepare the family and start preparing your argument against detention. So assuming they do file a petition for detention, the state is required under the law to provide defense counsel with the complaint, a synopsis of the reasons for detention, and I'll show you what a detention petition looks like in a moment, any criminal history reports, any information used at the detention hearing. This is either to be provided to the public defender's office or private counsel if the state knows that the client is going to have a private lawyer. So any information, what it really means is any witness statements. If the state is going to proffer that there was, for instance, there's an eyewitness to the crime and they reported it to the police, they're required under the law to give the defense a statement, a police report summarizing what that witness says. So unlike the old system where there was very little, if any, discovery available at bond court, now there's a robust discovery available in bond court, generally not grand jury proceedings and cases that are directly indicted. Most of the time, the case hasn't gone to the grand jury yet when you're at bond court anyways, but police reports. Then it goes on to a detention hearing. The defendant is entitled to have it within 24 hours on less severe cases, 48 hours on more severe cases. But a practice note here, to rush into a detention hearing on a serious case, such as a homicide case, even at the first appearance date, can be a mistake. Judges are not looking to let somebody out on a homicide case unless there's or any serious case that could be a sex assault case, unless there is a good reason to do it. And what I'm referring to on a homicide case in particular is I don't recommend going to a bond hearing the first day there, because to have a real shot at getting the guy out, you need to be able to launch a defense at a mini trial, the bond hearing. It could be a self-defense case. It could be an identity defense. But to rush into it at the first court date without having any witnesses lined up, or on a sex case, for instance, being able to show that the defendant doesn't pose a threat to the complainant, maybe you need time to find a different place for the defendant to live. For instance, in a case of a family member, to rush into a case where a parent or step-parent is accused of a sex offense against a victim and the state's asking for a detention, the judge isn't likely to let the person out and go back to the same house as the victim. The defense lawyer needs a plan as to where that person should go. Now, of course, your client is going to be anxious and eager to have a bond hearing to get out, but your client has to have enough confidence in you to know that it's best for them if you might have to wait a day or two or 3 or a week in order to put your best case forward for release. Another practice pointer, if you are going to go that route, if you are going to suggest to your client, wait a few days, let us get our ducks in the row. Number one, very important, you get to court early and meet with the client in the lockup to explain that to him. Number two, as soon as he is held, have a Zoom meeting or go see the client that day in the lockup so you could hold his hand while he's sitting in custody waiting for his detention hearing. But in some cases, it's good to wait and not rush into the detention hearing. On other cases where you're optimistic that you're going to get the client out, of course, you should go forward on a detention hearing. For instance, on a misdemeanor domestic battery case, that's a case to go forward that day and not have the client sit. Let's assume that the the real standard is, on most cases, whether the defendant poses a threat to the safety of any person or any persons in the community. There's other cases where they could detain someone based on a willful flight, but that's less common. That's usually if there's a fugitive that he's been evading a warrant that's been out for a long time. You can't really, they're not holding people too many just because a guy has a failure to appear in court in his background. So most of the fights are about whether the person poses a threat to any person or the community. So if the judge does find that the person is detained, they're given a next court date. And we're going to talk about it in a moment. The person can request a review of the detention order at every subsequent court date. But if they are not detained, then you go into a conditions hearing. And the most salient condition that defense lawyers fight against is electronic home monitoring. Now, there are some cases where we're thrilled that the judge would give the client electronic home monitoring when the state is asking for detention. A sex assault case or a homicide case or a case where a victim's badly injured. We propose electronic monitoring as a condition in lieu of detention. But on a case, for instance, a violation of an order of protection or a misdemeanor domestic battery, often the state's asking for this electronic monitoring, and it's often greater than necessary, and it's a burden for our clients. And it doesn't do them much good because many on those cases, they don't have a mandatory minimum. It's one thing if there's electronic monitoring on one of these firearms cases that carries a mandatory minimum term of imprisonment, then a bracelet can eat up some of the time that the person would face if they're sentenced to prison. But on a case where nobody was injured, it's good to fight hard against the electronic home monitoring. It's a real burden for the client. And you'll see in a moment, the next slide, there's a conditions hearing. So you're entitled to argue about what conditions are the least restrictive. After the conditions are imposed, the defendant receives the next court date, he is released. One other reason to argue against electronic home monitoring on a not too serious case is that'll delay the time that the person is in custody. So even if they're ordered released that same day, if they have to have a bracelet affixed to them, they might not get released until 2 a.m. And that's assuming they got a host address that they can be released to. Sometimes it takes days or over a week to get a person released. If a person's released with minimum conditions, they're usually released about 5 or 6 p.m. that night. By the way, they are permitted to make a phone call from the jail, and they are getting those to call their family members to say, here, pick me up, I'm getting released. Okay, so you're a lawyer, you get a call, you got to go over to bond court. I'm going to tailor this a little bit to Chicago, Cook County cases, but if there's bond courts on suburban cases during the week, there's a little bit different times, but I'll address that. So Chicago cases are held at 12:30 and 11:30 for homicides and sex cases. The first thing to do, if I'm a lawyer, I get the call. That morning at about 10 or 10:30, you could go onto Odyssey and you click on the case filed packet. You could get the arrest report, you could get the criminal complaint, and if the state was prompt, you might be able to get a copy of the petition for detention, if there is one. Then I would call the clerk and let them know that I'm coming into the case. Please hold the case for me, and you're going to file an appearance. That does two things. One, it lets the public defender who gets there early to talk to all the in custody defendants. It lets them know sometimes that there's a lawyer, and they can, any information they gather, they could tender to you. And sometimes they're able to tell the client, your lawyer's on the way, you're going to have a private lawyer. Then I would e-file my appearance, but also bring a copy to court, particularly on the weekends. You're not going to get an appearance accepted on e-file before the bond hearing in all likelihood. Then I will call state's attorney's office. There's the numbers. I'd be happy to share this slide with all attendees and ask if they're moving for detention. You could give the family a heads up that way, and you could start formulating arguments in your mind for release. Here's the new schedule. Everything's in person these days. Happy to share this with you. This is for Chicago and other Cook County cases. Don't worry about taking notes. I'm happy to share it with you. The thing to know is pretty much every bond hearing is in person. There's different times for continuing bond hearings. Sometimes hearings are commenced and continued based on witnesses, and there's different times. Happy to share this with you, though. This is what a petition for pretrial detention hearing looks like. This was a real petition that I encountered last week on a misdemeanor domestic battery case. I've redacted the defendant's name, but this is what they look like, where the state files a petition for detention. You can see they check the box. Here, my client was charged with domestic battery. My client happened to be a Chicago police homicide detective, but still they were moving for detention, and they claimed that he posed a real and present threat to a person. Domestic battery, even though it's a misdemeanor, is a detainable offense. Okay, they also had checked the box for a likelihood of willful flight, but they didn't argue that. What they argued instead is, here's the little synopsis that we talked about. This is what detention hearing petitions look like. They give a fact or two as to why the defendant is a threat. Okay, so I've talked a little bit about what's going on with the lawyer before the first appearance. Here's what's going on in court. First of all, the hearing must be in person. No more Zoom for these important hearings. They have to give the lawyer sufficient time to confer with the client before the hearing commences. That's statutory. The court shall appoint counsel if the defendant is indigent or unable to have a lawyer at that bond hearing. I note here, sometimes people receive a citation or summons. That's common on a small possession of a drug case or a bar fight, or a less serious misdemeanor. Class B and Class C misdemeanors are mostly getting summonses. That's good. That's a good change in the law. Before, the defendant would have to go to the police station. Sometimes they'd have to post $100 or even sign an I-bond, and it would take longer. These summons are getting people turned out of the police station quickly, and it contains the court date. Okay, there's notice to the victims. This is part of the statute. So a victim can appear at the hearing. A note for defense counsel, you could also request that the victim be compelled to be at the hearing. Judge doesn't have to allow it. You could excuse the victim for good cause. Many times victims are excused, but I recommend if it's a close case, requesting the victim's presence, even if the judge isn't going to grant it, is a way to signal to the judge that you're not afraid of what the complaining witness is going to say in this case. Maybe it's a domestic battery where a wife is likely to forgive the husband. That might be an okay case to try to request the presence of the complainant. So, but you're permitted to request that now. So pretrial services does a risk assessment, and judges can consider this as one factor. It's not a determinative factor. They look at the risk for new criminal activity, and they look at the person's prior history and risk to non-appear, and they give a scale. A new item in the statute: defense counsel is entitled, if they want, what information pretrial relied on in making their assessment. So for instance, you can look at their criminal history report. Is pretrial considering arrests or only convictions? You can challenge the tools that pretrial relied on. That's under the statute. And once in a while, that's a good idea. You should really look at what pretrial relied on. And if you get to court early and you get the pretrial risk assessment, the folks from pretrial are there. You could talk to them. You could say, why did you make my client a level 3 on a new criminal activity? He's only got a one prior conviction. And they could say, well, it's because it's a violent conviction. At least you know what you're walking into, what that pretrial score is based on. All right, this is the key to the new law. First thing, you have to see what is a detainable offense and what is not. This my father, my law partner, taught me, as well-meaning as the state's attorneys are, don't learn the law from them. And there's a long list because they're busy and they don't know every single detainable offense. So sometimes a petition for detention might be based on a non-detainable offense. So you carefully cross-reference the statute. Here's a list of detention-eligible offenses. Obviously, forcible felonies are included. One notable exception, aggravated battery where there's not great bodily harm, that's not detainable. Be careful on that one. Now, if it was because of something to do with the victim age, or if the victim was a police officer, it could be an aggravated battery that are that's not based on bodily harm. So, or if it's on a public way. So be careful that those are non-detainable offenses. Many serious sex offenses you can see are, of course, murder offenses. Second-degree murder is a detainable offense. The list goes on. I want to highlight for you in the Section A3, violations of orders of protection, including violations of no contact orders, civil no contact orders, or stalking. They're often misdemeanors. They're detainable offenses. Same with domestic battery, misdemeanor, detainable offense. Most sex offenses, even nonviolent ones, detainable, promoting prostitution, for instance. So, child pornography is a detainable offense. So you have to look careful. Public indecency is not. So you got the bottom line, look carefully to make sure that the offense in the statute is a detainable offense. If it's not, that's your first word to the judge. Gun offenses, a lot of them are, but that probationable violations of unlawful use of a weapon, for instance, possession of a firearm that's maybe not loaded or not immediately accessible in a vehicle. It's probationable. So the defendant might be eligible for a first offender weapons program. If it's probationable on a violation of the UUW law, unlawful use of a weapon, non-detainable. So look carefully to whether your gun offense is probationable. If it is, you should argue against detention. Aggravated DUI, reckless homicide, these are all detainable offense. Attempts to commit any detainable offense is the same as for the purposes of detention. Stalking cases are detainable, stalking and aggravated stalking. Some drug cases are detainable based on where the alleged offense happened, if it's within 500 feet of a school. So, but on those cases, the state has the burden to prove not just that the person poses a threat to somebody's safety, but also that there's a serious risk to not appear. So that one has both burdens on the state. But for most of the detainable offenses, it's just one or the other. So on the willful, when the state is trying to detain someone based on a willful flight. That doesn't fly, no pun intended, on lower level offenses. It has to be at least a felony that's class 3 or above, or there's certain serious class 4s. So for instance, misdemeanors aren't eligible for someone to be detained on the willful flight standard. And again, if the state argues willful flight just because the person has failure to appear in court in their background, that's not enough. They have to point to other specific articulable facts why the person's not likely to appear in court. And if they do, that's a good argument then for, well, judge, you could put a bracelet on them. Obviously, electronic monitoring is not foolproof, but that would be a good counter if the state has a strong willful flight argument. All right, so just because you win the issue of detention, maybe your client's not detained, but then you got to go on to the conditions hearing. And the law is that the court is required to impose the least restrictive conditions possible. Again, what this the usual battle in these cases is whether a person's going to be on electronic home monitoring, or they might be on a GPS in the case of domestic violence cases. And the statute has factors for the court to consider in section 110-5, similar to the old statute. But the court considers these factors right in the middle of the page there in fashioning the conditions of release. And I want to reiterate that the defendant is entitled to have the conditions reviewed at every subsequent court date. So if there's a change in circumstances, the defendant's on a electronic monitoring, he gets a new job that requires him to work 5 days a week and at different times, you can bring that back up to the judge every court date. Good practice, of course, would be to have a written motion beforehand, but not required to. The judge, you could bring it up to the judge. We'd like a review of the conditions. But as I say, of course, good practice is to come in, explain exactly why, with supporting documentation, the person needs a modification of conditions. Talked about the detention hearing start. We're going to get into more of the timing of the petitions, but it's this law everyone needs to know. The state has to file the petition for detention either at the first court date, which is the initial bond hearing, or upon reasonable notice to the defendant within 21 days after the defendant is arrested and released. So maybe a defendant is released on a summons, but they hear that, but the state hears he's harassing a victim. They have 21 days to move for detention from the defendant's release. So, and there's a brand new case that came out. There's a citation. It came out from our first district here on March 18th, People versus Watkins-Romaine. I have the site later in our in the PowerPoint, but our appellate court is holding the state rigidly to that 21-day term. It's not allowing, gladly I shall say, the state to file a petition to detain months after the defendant's arrest just because a defendant wants to review his conditions. So this 21-day rule is firm. The conduct of the hearing, I talked about it a little bit. The defense has a right to present witnesses too. If you had a great character witness, you might want to call that person at the bond hearing. Really, what I see it for is more like federal court. If you were proposing that the defendant be released to a third-party custodian, that's common in federal court, less so in state court, but it is in the state court bail provision that if you had the third-party custodian where the defendant was going to be released to be supervised, that's particularly in the case of a younger defendant, that he would go live with his parents and he'd stay away from his girlfriend, something like that. You might want to have the proposed third-party custodian there to testify. You have a right to present witnesses under this law. You have a right to cross-examine any witnesses that the state calls. I have not seen the state call any civilian witnesses, and it's very rare that they even call a police officer so far. But if they did call, they generally proceed by way of proffer, the preliminary offers of proof. But if they did call a witness, the lawyer has a right to cross-examine the witness. Okay, the standard here is clear and convincing evidence. So if the state is alleging that the defendant is a danger, they have to show that the proof is evident or the presumption great that the person committed the offense. Usually the state gets past that burden fairly easily. 2, that they pose a real and present threat to the safety of a person or the community. They get past that easily. Paragraph 3 is where the argument lies for defense counsel, and that no condition or combination of conditions can mitigate the real and present threat. This is sometimes the soft spot where a defense can argue, okay, they showed that he's a danger, but judge, look, we're going to put him on a bracelet. You're going to make sure he's in a substance abuse treatment facility. There are conditions here that can mitigate the threat. Judges are more sympathetic to that argument, I found, than whether or not the guy poses a threat. Of course, we argue that he's not a threat, but that last element is a good argument for us. Okay, there's as I said, for drug cases, they have to show that he's also flight risk as opposed to just dangerousness. We talked about what they have to show for willful flight. It's a high likelihood that he won't appear. There has to be some intentional conduct, basically, in the defendant's background or something about the case that shows he's evading process. If the court decides to detain the defendant, they have to make written findings summarizing why less restrictive conditions would not avoid a real and present threat. So early on, when the new law came into effect, some judges were just checking boxes that the defendant posed a threat without detailing why. Some of those cases got reversed, and so a judge has to put a few sentences at least as to why the person is a real and present threat on the detention order. If they don't, that's a good reason to appeal if it's just a very cursory order. But in the last several months, most judges seem to be filling out the orders correctly. Either party may appeal a detention order. I'm going to talk about appeals later, but there's notice of appeal forms on the Illinois Supreme Court website, and supposed to you file the notice of appeal within 14 days. There's a law by the way. I want to reiterate this. March 15th, the Supreme Court Rule 604H that governs appeal was amended. Practitioners, you now must file a motion for reconsideration before the trial court, before you appeal. Otherwise, it's going to be deemed waived. It's kind of like the rule on regular appeals, but this is the law now on appealing Safety Act detentions. You got to first go back to the trial judge with a motion to reconsider saying why the person should be released. If you don't, the issues will be deemed waived on appeal. All right, let's talk about people who had a bond. A bond was set before the law took effect and before January 1st, 2023. Maybe a defendant on a serious sex case, they said a judge had set a bond as $500,000 D, $50,000 to get out. They've been sitting in there for a year or two. They can't get out. You could request that they have a bond hearing under the new law. Now, there's some things to consider. Up until this brand new case of Watkins and Romaine, Watkins-Romaine, I was advising people, be careful, at least with under your old bond. $50,000 is a lot of money, but maybe a family member can post it. If you go and ask the judge for a new bond hearing under the law, they could be held no bond, because that was happened. The state was doing this. But Watkins-Romaine just issued 3 days ago, clarified that no, just because the defendant asks for a new bond hearing, the state can't just turn around and ask to hold them. Instead, there's this 21-day requirement still applies. So it would be too late, since the case was pending for a year, for the state to ask to detain them just because the defendant wanted a bond hearing where he was previously held on because he couldn't post bond. The new case says the state is really held to the language of the statute. If they didn't move for detention within 21 days of the defendant's arrest and then his released, or at the first court date, they're time barred from doing it. There's been a split in appellate authority on this, but this is a brand new case out of the first district. So we're hopeful that the state will abide by this law and not seek to detain people just because a defendant is asking for a hearing where they are unable to make bond, and now the new law came into effect. And people are still able to post bond. If for some reason say it was a bond where it was $10,000 to walk before, the defendant wasn't able to raise it, but the family now has it. Just because it's the new law doesn't mean they can't post bond. They can still post bond. So you do have to, there are some considerations to decide whether you want a bond hearing. As I say, not every judge, not every state's attorney is going to interpret this new decision the same way. So if the person does have a monetary bond, the best thing to do, if the family could afford it, is post it. If not, then it's worth it to have a bond hearing. Okay, here's the alarm clock on the state now on the Watkins-Romaine case. Here's the citation to the case. Judge Lampkin delivered the judgment of the court for the appellate court. And it says, now the state can't just wait to move to detain someone just because the defendant asked for a bond hearing where they had a previous bond. Now, I will say, unfortunately, this is not the rule for people who were held no bond. This rule out of Watkins-Romaine and the statute applies for people who had a monetary bond. They just weren't able to afford it. They couldn't post it. So in that case, if the state didn't move in a timely manner, they could get released. But for those who, like a homicide defendant that I have, who didn't have a bond, the state isn't held to that 21-day rule. Instead, the defendant has to petition for a bond where he's eligible to. He could ask for a new bond hearing because of the new law, but the state then gets a chance to respond. I'll talk about that in a moment. Assuming your client is held, the bond statute contains a new speedy trial provision. So if it triggers a 90-day clock. Generally, speedy trial is 120 days for those that are in custody, 160 for those who are out on bond. But under the new law, if a defendant is held and they demand trial, they have to be brought to trial within 90 days. So if they're not, the remedy is release. So something to think about. I would say this really comes into play in where DNA cases are an issue. The state might have a hard time getting on the grid for a DNA on a sex case. If a guy is being held, you might want to consider invoking the 90-day speedy trial provision. State might not be able to give him a trial within 90 days. Obviously, I want continuances that are requested for the defendant on bond hearings and the like, those don't count towards the 90-day period. Okay, this is the situation that I was talking about. You have a client who was held no bail under the previous bond statute. You could ask to be held, you could ask for a bond hearing. The defendant's not barred from requesting a bond hearing. And if you do, they have to give you a hearing with either 90 days, 60 days, or 7 days. The timeframes are in the statute. It goes based on the seriousness of the offense. So for homicide cases, for instance, the state has 90 days to get their ducks in a row to give you a bond hearing. If your client was previously held no bond and you want a bond hearing. Not a bad way, not a bad move to ask for the bond hearing. One, you could take the judge's temperature on the case and see if the judge, how he or she feels towards the case, and helps the lawyer determine whether to take a bench trial or recommend a jury. And two, the state has to give a meaningful proffer these days. So it's a preview of their case. But of course, we all know that if there was a no bond order on from a previous judge, that's hard to get overturned by a different judge in the same courthouse in particular. Appeals. Appeals are important these days. Practitioners who don't do appellate work, you should know how to appeal a bond order, because the appellate court is really considering this. They granted relief in some situations. They are flooded with appeals. In about 5 months, there was 1,900 detention appeals compared with 17 annual under the old system. And there's special unit of the public defender's office that's devoted to this, and they're doing pretty good kicking out the opinions. And in fact, there's a new rule just took effect 3 days ago that from the time of the notice of appeal, and this is in Rule 604H, it has to be no more than 100 days from the time of notice of appeal to the disposition. So in 3 months, your client in custody could get a ruling. That's pretty good. All right, Rule 604H is what guides everybody on these detention appeals. It was amended, as I say, a few days ago on March 15th. Biggest thing to note for trial court practitioners, you must now file a motion for reconsideration in the trial court in order to preserve the issue for appeal. It's 604H2. They call it motion for relief. It's a prerequisite, it says, to the appeal. So, and any issue not raised will be deemed waived. So don't do just a cursory motion for reconsideration if your client is denied. You bring a robust bond motion that'll preserve the issues for the appellate court. And by the way, when you do appeal, although you're not required to file a memorandum in support of your notice of appeal, or you should treat the appeal like a real appellate brief and file what they call a memorandum in support of the bond review. The notice of appeal, you could appeal while the case is pending. Unlike other appeals, you don't have to wait for there to be a final judgment. You could appeal anytime before the conviction. And as I said, notice of appeal forms are on this Illinois Supreme Court website. They're particular forms for bond reviews. So I would grab it from there. Important to note that while the appeal is pending, the circuit court retains jurisdiction. So what does that mean? That means, for instance, if your client is on electronic monitoring and you want to appeal that issue to the appellate court, you're not barred while that appeal is pending from asking the trial court to revisit it as well. Counsel, you do have a duty to inform the appellate court. If the trial court granted your motion to, let's say, remove electronic home monitoring, and you're appealing that issue to the appellate court, you have a duty to inform the appellate court, the issue is now moot. Don't worry about it. So that's in the rule, the duty. under 604H11, no subsequent appeals while the first appeal is pending. So if your client's denied pretrial release, you appeal it, you go back to the trial court, he asks for pretrial release again, trial court denies it. You can't go a second appeal to the appellate court. One appeal on the issue of conditions or release while the first appeal is pending. This is what I was talking about. You have to file a motion for relief. It's a memorandum. Don't just rely on a notice of appeal in the trial court record. It says they may file, but not required. But in real life, to be persuasive, you should lay it out for the appellate court with a memorandum. You have 21 days within the filing, from the filing of the record on appeal. The circuit court is supposed to promptly file the record. I believe it's within 30 days, but practice pointer, stay on the clerk to do it, because if you don't, sometimes it can go for months before the appellate court files the record. State where the appellee gets a chance to respond. Remember, the state has the right to appeal these detention orders too. So there's the timeline, new timeline. It's shall not exceed 100 days from the notice of appeal to disposition. So the appellate court will issue a decision shortly after 3 months. On appeal, it's tough to have the appellate court overturn a trial court's factual finding because it's a manifest weight of the evidence standard. A lot of the cases say the decision on whether to detain someone is reviewed under abuse of discretion. There's been a concurrence here or there that says that the whole decision should be reviewed de novo, but the overwhelming majority of cases say it's a abuse of discretion standard. The appellate court will review de novo from scratch whether the proper procedures were followed. So in the case I was talking about, Watkins Romaine, whether the state timely filed their petition, that was reviewed de novo. Of course, that's your best chance of relief if there was some procedural defect that affected the defendant's rights, because that's reviewed de novo. I am here is my information, but I'm going to open it up. I see we're at 1 o'clock. I'm going to open it up to questions. And let me see in the chat here, or ask Aviva if there
I mean,
are.
I know that's a lot of content, and people might be taking a moment to think about questions, but there's nothing in the chat on my end unless someone directed it to you. We just got another criminal law attorney who said comprehensive enough that I can't think of any good questions.
I'm going to give a side note for private counsel. Bond hearings merit a significant fee these days, not like the old days where you're just going to appear in court. They're mini trials. So to do it right, I'm talking about a serious case, a serious sex case, or a case where somebody was injured. Honestly, to do it right, you should have the family in the office. If you get a heads up about your client being arrested, you could have affidavits drawn up, memorandums in support of release. They're like mini trials these days. Contact the state early, get the reports, and you should ask for a greater fee than you would have in the old days. It's not shoot from the hip anymore, not good lawyering at least. So if there's any other questions, I will be happy to field them. I'm not seeing any. You guys could always feel free to contact me. I'm happy to share all the information.
Yeah.
Okay.
Okay, well, we still have another 10 minutes to go. Oh, here we go. In terms of more minor offenses, what does the change look like?
The change looks like that people are being released right from the police station without having to post any monetary bond whatsoever. And also for felonies, low-level felonies, such as there are some drug cases that they're being released right from the police station. So that's a change. And they don't have, when I say right from the police station, I'm talking about immediately, right upon their arrest. Whereas before, there might be a $300 bond that somebody had to post at the police station, or $100. That's all gone. And so it's really helpful for low-level offenses, and for not so much in Cook County. In Cook County, on a low-level offense, the retail theft, most of those defendants were getting out on recognizance bonds anyways. But in some collar counties where they're trying to raise money, that person could have faced, they needed a couple $100 to get out. That's really helpful to them, the new law, because they don't have to worry about posting money. So I see a question here.
Yeah, I think Hy Reepman has a question, and then we'll go back to another one.
You know, Judge Reedman's question, I'm looking here.
Yeah, can you unmute yourself? I think I gave everyone the permission to.
You seen any instances where a defendant chooses to testify in a detention hearing, or he's pro se and he decides that he's going to make a comment? And if so, are those statements possibly usable against him down the road?
I believe they are. I haven't seen it. Of course, most lawyers would recommend against it, particularly at that early phase. Though I suppose if you have the right defendant on a motion to reconsider, if you want the judge to meet your client, in the odd occasion you want that, it might be okay. It's a good question though. But practitioners, make sure you get the transcripts from the hearings, particularly if the state calls a witness. And also the proffers, given that they're more meaty these days, it's good to get a transcript of the state's proffer. Sometimes you could even get it in the discovery. If you ask them, they'll tend to typed up. I had a case in Lake County on a homicide case where I was able to get the proffer.
We have another question here asking, can the defendants still put up 10% or must they put up 100%?
No more cash bail. Oh, you mean for pre-existing bonds, it's still 10%. So if it was a $10,000 D bond before the new law, they could still, it's still $1,000 to get out 10%.
And then another question, the apocalyptic prediction suggested that it would be pandemonium in Chicago. Has it been worse than usual?
No, all the reports are not. And if you go onto the Illinois Supreme Court website, they have a whole section for pretrial fairness. If you look at the data, it hasn't been pandemonium. And in terms of apocalyptic prediction, I predicted the apocalyptic issue of all court detention for people who should be out. And because it used to be in the old cases, on any type of case that has any heat, a sex offense with a proof of other crime, for instance, a judge would set a high bond, understandably, to convey the seriousness of it and try to protect the public. But now it's no bond. At least under the old ways, the defendant had a shot of getting out of jail. And of course, us practitioners know it's much harder to prepare a case for trial and keep a client's confidence too when they're in jail. So if your client is in jail, I Zoom with my clients usually every other week for those who are detained. It helps keep their confidence, and Zoom's great because you could put the documents on the screen, the police reports, and review it with the client. So if you have a client that's detained, make sure to set up Zooms with them on a regular basis.
And just following up on that, we are planning next year, maybe around this year, to have a CLE that talks about what the effects of the law have been. Hopefully Adam will come back to talk about it from the defense perspective, and we'll get an assistant state's attorney to come and talk about it from the prosecutor's perspective. So look for that next year. We have another question here in the chat. Is there always a court stenographer from whom you can order a transcript?
Yes. Yes, good. It's a good question. Yes, I know in civil cases, sometimes the lawyer has to request the court reporter to be there, but there is always a court reporter at these bond hearings, all criminal proceedings. I see that Judge Jordan had asked the question of what changes I anticipate with a new state's attorney in Cook County. You know, many new state's attorneys tout tougher on crime slogan, understandably so. And I hope that doesn't lead to more requests for detention, but that is, I wouldn't be surprised for any new administration to start off that way. There's a lot of requests for detention anyways. On misdemeanor cases, it's a little more than I would have hoped for. But I anticipate it'll only be more at the onset of a new administration. Although I don't think Justice Burke has specified if she is the state's attorney or if it's a different state's attorney, what exactly, but that's not their position. I'm not holding them to it. I'm just saying, generally speaking, a tough on crime slogan is instituted in early in administrations.
Okay, we've got a couple more. And one question is, did I understand that time on electronic monitoring acts as an offset to any time to which the defendant may be sentenced?
Yes, that's a relatively, it's a relatively new law by statute. Entitled, it's not discretionary. The defendant is entitled to credit in jail when they're on electronic monitoring. So, for instance, on a gun case, let's say it carries a mandatory 1 year in prison, which is 50%, 6 months. If the case is going on for 6 months and the defendant is on the bracelet the whole time, it's what we call a turnaround time. They go to the jail, dress in and dress out, and they're released. So there are some cases where my client's facing a mandatory minimum. I wish he was on the bracelet so he could eat up some of the time he might be facing. So you gotta be careful to fight against the bracelet. Sometimes the bracelet will be welcomed or okay. Client doesn't love it at first, but it's helpful towards the case.
And then we have another question here. Just one of our members wants to clarify that under the new law, you are either detained or let out with or without electronic monitoring, no cash bail whatsoever.
That's correct. No cash bail whatsoever. It's either you're held or released with or without electronic monitoring. And there's other conditions from different than electronic monitoring too. They could put a scram bracelet on, for instance, in case of an aggravated DUI to determine if the person is drinking alcohol. You could expect in a case where there's a victim, of course, no contact with the victim. In retail theft cases, you can't go anywhere near the store. Those are common conditions. And we handle a lot of fraud cases. Sometimes on those cases, there's conditions about, there's some financial conditions about opening.
Okay. Are there any other questions? Well, if there are no other questions, I just want to thank Adam very much. Oh, I'm sorry. Hi, Reedman has another question, I think.
Adam, I just wanted to ask you if there are a lot of instances where there are violations of detention orders where they've been let out.
There's been a number. Thank you for reminding me of something, Hyde. The old days, if you violated your bond, you could have your bond revoked.
Right.
Not anymore. And you can't have the way to get your bond revoked now. You have to commit at least kind of a serious felony. Now they're called sanction hearings. So if you're on electronic monitoring and you blow it off, or you violate your curfew, a judge could lock you up for 30 days, but can't revoke your bond indefinitely like they could before. But there hasn't been that many instances that I've seen personally. This is just anecdotal. I don't have the stats. Most people are abiding by their bond conditions. So it's been, those who have been released are seeming to comply. There are instances. I have a client who picked up a new case, but I don't have the numbers, but I don't see it that much in the trenches.
Okay, anything else? I don't want to cut it short if anyone has anything else they wanted to ask. This one is asking you your opinion. For the most part, are you happy with the new law?
Personally, I'm not. I've been blessed mostly to have some clients who could afford to post bail. And here in Cook County, we have reasonable judges who will set reasonable bonds most of the time. This takes the discretion out of a judge's hands a lot. It doesn't afford a judge that middle ground where, well, I'm not going to release them at an easy bail, but I'm not sure if I should hold them. And so we have a client now where I feel like on a sex case by saying, I'd like to argue, Judge, if this was the old days, would you keep them locked up or would you set a $500,000 bond and at least give the family a shot to post it? I don't have that argument anymore because it's either hold them or release them, and it takes that middle ground away from the judge. And us criminal defense lawyers like to operate in that middle ground. And I'm against the law because it's led to more detention. Yes, on more serious cases, but that doesn't mean that the defendant is a worse person. So defendants who are first offenders or are facing serious sex cases, for example, are detained more than they were under the old law. And I'm against that.
Okay, well, that sounds like a good starting point for when we meet again next year to talk about the effects of the law. So I want to thank Adam very much for this. Was a fantastic presentation. Thank all of you for coming. I am going to start the poll. Please fill that out so that we can meet our requirements for accreditation here with MCLE board. And I will also